Now, limitations on fundamental rights. All over the world, even in the historically deep-rooted democracies, there are limitations imposed on the enjoyment of the fundamental rights. Indian Constitution also contains them. Article 19 says these rights are conditional and subject to reasonable restrictions. Such reasonable restrictions are spelled out in Article 19 for some freedoms, while for others, such limitations are added through either amendment acts or Supreme Court verdict. For example, reasonable restrictions found in Article 19 are extended to Article 21 as well in the Menaka Gandhi case verdict by the Supreme Court in 1978. Article 15 and Article 16 of the Indian Constitution have also been amended by the Parliament in pursuit of social justice. Now basically, there are 6 types of fundamental rights that are incorporated in the third part, that is in part 3 of the Constitution of our country, India. They are from Article 14 to Article 18, right to equality. From Article 19 to Article 22, right to freedom. From Article 23 to Article 24, right against exploitation. From Article 25 to Article 28, right to freedom of religion. From Article 29 to Article 30, cultural and educational rights. Article 32, right to constitutional remedies. Now, right to equality. It is a very important right enshrined in Articles 14, 15, 16, 17 and 18 of the Constitution. It is the principal foundation of all other rights and liberties and guarantees equality before law, social equality and equal access to public areas, equality in matters of public employment, abolition of untouchability and abolition of titles. Thus, the state cannot discriminate against a citizen on the basis of religion, race, caste, sex or place of birth. Every person shall have equal access to public places. While equality for all is guaranteed, affirmative action in favor of deprived groups is constitutionally allowed for women, scheduled caste, scheduled tribes, children and certain other social groups which are termed as backward. Practice of untouchability has been declared an offence and anyone practicing it is punishable by law. This is covered in Article 17 of the Constitution of India. The state cannot confer any title and citizens of India cannot accept any title from a foreign state without the permission of the government of India. The titles which were very famous in the past, such as the title of Rai Bahadur, Khan Bahadur, have also been abolished. However, academic distinctions and military distinctions can be conferred on the citizens of India. The awards like Bharat Ratna, Padma Bhushan and Vibhushan, these awards cannot be used by the recipient of these awards as a title, and therefore if they cannot be used as a title, they does not come under constitutional prohibition. This was the verdict of the Supreme Court in 1995, which upheld the validity of these awards. Now, right to freedom. It is given in Article 19, 20, 21 and 22 of the Indian Constitution with the view of guaranteeing individual rights that were considered vital by the framers of the Constitution. The right to freedom encompasses the freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations or unions, freedom to move freely throughout the territory of India, freedom to reside and settle in any part of the territory of India, and the freedom to practice any profession or to carry on any occupation, trade or business. Restrictions can be imposed on all of these rights in the interest of public order, security of the state, decency or morality. The Constitution also guarantees the right to life and personal liberty, and says that the right can be limited or denied in a way that is prescribed by the law. Protection with respect to conviction for offences, protection of life and personal liberty, and the rights of a person arrested under ordinary circumstances is laid down in the right to life and personal liberty. However, the right to life and personal liberty cannot be suspended under any circumstances, even under the circumstance of a national emergency, which is imposed according to the provisions which are mentioned in Article 352 of the Indian Constitution. That is right to life and personal liberty. That is Article 20 and Article 21 of the Indian Constitution. They cannot be suspended even in the case of national emergency. Now, right to education was added by the 86th Constitutional Amendment Act 2002. And it has been made as one of the fundamental rights under the right to life and personal liberty as mentioned in the provisions of Article 21A of the Constitution of India. This I have already told in the previous lecture. It is in line with the expanded reading of the right to life that the Supreme Court introduced since late 70s. Now we come to right against exploitation. Now, right against exploitation. The right against exploitation given in Articles 23 and 24 provides for two provisions. These two provisions are: first, the abolition of trafficking in human beings; second, the abolition of employment of children below the age of 14 years in dangerous jobs like factories and mines. Child labor is considered a gross violation of the spirit and provisions of the Constitution. Trafficking in humans for the purpose of slave trade or prostitution is also prohibited by law. Compulsory military conscription is, however, permitted. Now, right to freedom of religion. Right to freedom of religion, covered in Article 25, 26, 27, 28, provides religious freedoms to all people of India. The objective of this right is to sustain the principle of secularism in India. According to the Constitution, all religions are equal before the state, and no religion shall be given preference over other. Citizens are free to preach, practice, and propagate any religion of their choice. However, certain practices like wearing and carrying of kirpans in the profession of the Sikh religion can be restricted in the interest of public order, morality, and health. Religious communities can set up charitable institutions of their own, subject to certain restrictions in the interest of public order, morality, and health. No person is compelled to pay taxes for the promotion of a religion. A state-run institution cannot impart religious instruction. Cultural and educational rights. Cultural and educational rights are given in Article 29 and 30 of the Constitution of India and are measures to protect the rights of the minorities, whether it is a linguistic minority or whether it is a religious minority. Any community which has a language and a script of its own has the right to preserve and conserve and develop it. No citizen can be discriminated against for admission in state or state-aided institutions. All minorities, religious or linguistic, can set up their own educational institutions in order to preserve and develop their own culture. In granting aid to institutions, the state cannot discriminate against any institution on the basis of the fact that it is administered by a minority institution. Now, right to constitutional remedies. Article 32 confers the right to move the Supreme Court directly in case of any denial of the fundamental rights. For instance, in case of imprisonment, the citizen can ask the court to see if it is according to the provisions of the law of the country. If the court finds that it is not, the person will have to be freed. If the court finds that it is not, the person will have to be freed. This procedure of asking the courts to preserve or safeguard the citizens' fundamental rights can be done in various ways. The courts can issue various kind of writs. This is also known as the writ jurisdiction of the Supreme Court. These writs are habeas corpus, mandamus, prohibition, quo warranto and certiorari. I have explained you these writs in one of my audio lecture, and I have also composed a full article on the writ jurisdiction. You can see it in the GK article section, and you can also listen the audio by listening the audio of writ jurisdiction on my audio page. You will find the audio link on my audio lecture page on my blog gs-india.blogspot.in. Now next, significance of fundamental rights. Fundamental rights primarily protect individuals from any arbitrary state action, but some rights are enforceable against private individuals. For instance, the Constitution abolishes untouchability and also prohibits beggar. These provisions act as a check both on the state action as well as the action of the private individuals. However, these rights are not absolute or uncontrolled and are subject to reasonable restrictions as necessary for the protection of general welfare. Explanation of Article 1235. Article 12 defines the state as including the government and the Parliament of India and the government and legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India. Article 13. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. Now, after listening this line, you should know the meaning of law. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usages having in the territory of India the force of law. And nothing in this Article 13 shall apply to any amendment of this Constitution made under Article 368. Next is the Doctrine of Eclipse. The doctrine says that a law that is overridden by a subsequent law does not cease to exist. It only goes into dormancy. Once the overriding law is diluted or deleted, the earlier law comes into operation. For example, a pre-constitution law goes into eclipse as the constitution comes into effect and overrules it. When the constitution is amended allowing the pre-constitution law to resurface, it comes out of eclipse. It does not apply to the post-constitutional law as they become null and void from inception if they contradict the Constitution. The doctrine applies to fundamental rights part 3. If a pre-constitutional law is inconsistent with the fundamental rights, it goes into eclipse. But a post-constitutional law is void ab initio and the question of going into eclipse does not arise. That means that if any law which is made after the drafting and coming into force of the Constitution of India violates the fundamental rights, it immediately becomes null and void when a court declares so. But if a pre-constitutional law is inconsistent with the fundamental rights, then after the starting of the Constitution and after the Constitution of India coming into force, that law goes into eclipse. But it is not the case in post-constitutional law. that is laws that are made after the implementation of the Constitution of India. Now Article 14, equality before law. The state shall not deny to any person equality before the law or equal protection of laws within the territory of India. Equality before law means that irrespective of any other criteria, all citizens and others are equal in the eyes of law. The exception in certain matters is the President of India and the Governor of a state. Equal protection of law means like are treated alike, or people in similar circumstances are treated similarly. For example, persons having the same taxable income have to pay the same amount of tax. Now, rule of law. Rule of law is a basic feature of all modern constitutional democracies. In explaining the rule of law as a characteristic of the English Constitution, Professor A.V. Dicey delineated the following three dimensions. Firstly, the rule of law means absence of arbitrary power on the part of the government. There is a written law that lays down rights and responsibilities of citizens and others. It also states clearly the powers, obligations, and limitation of the government action. The next dimension. Secondly, it means that no one is above the law and everyone, whatever be his rank or status, is subject to the ordinary law of the land and the jurisdiction of the courts. Third point. Constitution is not the source but the consequence of rights of individuals. As individual rights are enjoyed even before the emergence of the Constitution, and the Constitution only consolidates and codifies the same for legal protection. Rule of law implies many related notions like: first, the notion of equality and equal protection of laws as explained above. Second, separation of powers, since the fusion of powers in one authority is dictatorship or absolutism. Supreme Court of India, relying on Dicey, observed that the rule of law means that decisions should be predictable and citizens should know where he is. Now, at this point of time I am finishing my audio lecture here. From the next audio lecture I will tell you about the Article 15 of the Constitution of India. So thank you for listening my audio lecture. Now, limitations on